give John rent when the rent was due.
Ma'am, the lawyer has just told me someone else lives there. They had released the apartment.
But they refused to take the rent from me and did not notify me of this coming up. I was working with the case that was
okay. My file.
Today, we're diving into a jaw-dropping landlord-tenant showdown that escalated into a courtroom storm. On one side, CK Investments, armed with a default judgment and the legal right to repossess an apartment. On the other, Denise Kirk, who claims she was trapped in a nightmare of failed notices, chaotic mail, and hotel stays, desperately trying to get her life back. How did this case spiral from missed rent to claims of sabotage and injustice? Stick around, because we're breaking down every shocking twist, courtroom clash, and legal maneuver that makes this story unforgettable.
230714. This is CK Investments versus Denise Kirk.
Thank you, Your Honor. Paul Hugh, P31986, appearing on behalf of the plaintiff.
All right, thank you. And Ms. Kirk, tell us your name.
Denise Kirk.
And we're here today for a motion to set aside a default judgment. This is a landlord-tenant case. And apparently the judgment was entered on June the 6th, 2023 for $2,130. That is the amount of rent that was determined to be due for the
Why is it consent?
Is that me or you?
oh, that's this. Somebody moved this. That's the amount that's due for the defendant, Ms. Kirk, to retain possession of the apartment. And apparently that was done, I guess, by default judgment for failure to appear. All right, and so a writ was entered on June the 15th. And then
Your Honor.
this motion was filed after that. Yeah, Mr. Booth.
Yes, we would argue that this is moot. The writ has been executed, the apartment has been vacated, and has been leased, we believe, to somebody else.
Are you kidding? Really?
Yes.
So the writ's been executed, the defendant has been moved out, and someone else is living there?
Yes, ma'am. I believe that's the case.
Ms. Carr, do you still live in this apartment?
Yes, but when I was in court in the past year, I was trying to communicate to the court when I was here that it got so horrible in my apartment about a year and a half ago that I had to run away to a hotel to try to get into court to get my right restored so I could live normally in my apartment for the first time in 30 years.
Okay, now ma'am, here's a problem. We had a trial date on this where I guess, you could have come. You didn't come to, I guess, the first pretrial, May 22nd. So that's when we could have set it for trial, but we weren't here. So we entered the judgment. After the judgment was entered, I see we got some notices returned. So I don't know what address you were receiving your mail at, but the Sherman Street address mail kept coming back to us.
It's a mess.
So after that, they asked for the writ to evict, which I signed because we had a judgment. And they say they executed the judgment, meaning the court officer came, moved you out, or you moved on your own, one of the two. And they re-rented the apartment. So what you're asking me to do is set aside this possession judgment, which gave the plaintiff the right to have the apartment and have a trial on the issue of how much money you need to pay to stay in the apartment. But you're not in the apartment. So there's no basis for us to set this judgment aside. It's moot. You don't have any standing to even do it at this point because you don't live there.
I did live there, but I had to
Ma'am, but
stay away till I could
understand.
live in there normally.
But right now you don't, correct?
Well, I
Who lives in
living
this apartment number, whatever it is?
12.
12,
100.
112.
Yes.
Who lives there? You?
Yes, I have a voucher. I just
You
had.
live there right now? That's
No,
where
I
you
had I lived there, but I had to go separate from. the
Okay, ma'am, my
apartment
question is
temporarily.
easy. It's real easy. Do you have furniture and belongings and
I
go to
did.
that right this minute today? Where
I-
you go there and you sleep and you cook?
I did until this, whatever this is, I wasn't notified.
I know, I'm
that
talking
this was
about
happening.
today.
I
Do you
don't
live
know
there?
because I couldn't get in for my inspection.
Do you live there today?
I can't get in the door. I went for my inspection with the housing commission. It was rescheduled. The first
Ma'am, where
time
have you been living then?
I've had to stay in hotels I thought it would take 30 days a year ago to get into court to bring it, to the court to get this straightened out.
I don't
I
know,
was
because
denied a
this
right.
is their case against you to evict you for non-payment of rent. That's what this whole case was about. Now you want to set aside the judgment and have a trial on how much rent is due. And there is no rent due because you don't live there.
I attempted to give John rent when the rent was due.
Ma'am,
Refused to
the
take
lawyer
it.
has just told me someone else lives there. They have released the apartment.
But they refused to take the rent from me and did not notify me of this coming up. I was working with the case that was.
Okay,
within the
my
right.
file shows notice was given. Whether you got it, I don't know.
I didn't get it because my mail has to go to the hotel. If it goes to the apartment,
ma'am.
I don't know where it's ending up. It's all a mess for a
All I
long
know
time
is
with my mail.
all they have to do is send it to your known address, which was number 112 on Sherman Avenue. If you didn't check your mail there, I don't know why you weren't getting it.
And my
Now here's where the tension hits peak levels. Denise claims she tried to pay rent, yet the apartment was already occupied by someone else. Imagine the frustration. Money in hand, but doors slammed shut. Legally speaking, the court emphasizes that proper notice must be reasonably calculated to reach a tenant. That means sending it to the last known address, even if it doesn't actually land in your hands. But here's the human side. Denise says her mailbox was sabotaged. She was stuck in hotels, and everything spiraled into chaos. Who's at fault? The system, the landlord, or simple miscommunication? This is the moment you realize the emotional stakes go way beyond dollars and cents. It's about a person's right to live somewhere safely.
mail everything has been basically sabotaged, been a mess for a year while I've been trying to work this out in the courtroom. To gain my right. It's been a total nightmare. You go to your mailbox, you don't know if all the mail's there. It gets sent back to the post office sometimes, and then they can't find it at the post office. I've let the court window, the girls are lovely at the court window. I've let them know continuously that I'm temporarily in a hotel room, that, my mailbox is not secure, etc. While I'm fighting this battle in court to gain my right.
Well, Ms. Kerr, I can't do anything here. To set aside a default judgment, you have to show good cause as to why you didn't come and a meritorious defense. If you weren't getting your mail, now you've changed your address with the court. We have this new address.
No, I didn't change the address. I told them this is my, temporary.
Oh, ma'am, I don't know
place
what
of
you did,
staying while
but
I'm waiting for my apartment to be restored.
yes, ma'am, we just need a way to contact you, whether you live permanently or not. You have filed with the court this address on Stevenson Avenue.
Yes, I provided throughout the year continuously with the court window, the information that I'm temporarily in a hotel room. I am not in the apartment because it's not safe by law to live in there until my right is restored. That's what I've been trying to do in court for the past year. And I've never withheld rent from them. They did not take the rent. They did not notify me in a way that I could be properly notified for what this is that I'm here for today.
I don't know what to tell you. Everything I see has the last known address on it. Some of the things.
They know
Ma'am,
I'm not in there.
I don't know who
in
they
the hotel
is.
room.
I can speak to the court. We give notice. We don't know where you live except for the address on this case. And we did not have any other address. And we sent notices to that address and it came back.
because
All you have to do is give someone some kind of notice in a manner that's reasonably calculated to advise them of the hearing.
and
They don't have to actually know. It has to be reasonably calculated to give them that notice. Sending court documents to your last known address is reasonable. You didn't call the court and change your address temporarily or anything, so we would know where to send you any notices. We sent the notices properly.
I just let them know at the court window, the girls at the court window throughout the years, that I am temporarily in a hotel room. Even with the housing commission, I go and pick
Do
up
you know what
papers, I
this
don't want
says?
the mail.
This says your address on it,
Pardon?
temporary address. You gave it to us July 13th, well after the hearing for this case.
I heard about.
Well after the case was over.
I heard about this at the mediation conference on the phone at the end of the mediation from the lady who conducts the mediation, what the attorney was saying, and I had no knowledge of it.
Well, if you heard about that,
Court window.
mediation happened before trial. So if you heard about it from that, you should have known.
That was on June the 30th. I came right to the court window to ask them, what is this? Is there anything happening?
No, this judgment was entered on May 24th.
That was my first knowledge on the day.
Okay, well, listen, I've got to move on. I can't keep going back and forth. The good cause is non-existent because the notices went out. You failed to change your address.
My mail cannot be
Ma'am,
found.
this is a ruling. You do not argue with me in my ruling. You stand there quietly and listen to what the ruling is so you can learn what the law is in this area. You don't have to agree with it. You just have to listen to it. So the bottom line is there's no good cause for you failing to appear. And there is no meritorious defense. There cannot be a meritorious defense because you are no longer in possession of the premises. So there is no reason for the court to set aside a judgment to allow you to determine how much rent is due on a premises that you no longer live in.
Accept the rent.
Thank you, Your Honor.
Okay. That's the ruling of the court. And
Thank you, Your Honor.
there's $750. I'll just release that back to her.
Thank you. Yeah, that's
Does
fine.
your client want it?
No, Your Honor, she can have it. Thank you, Your Honor,
Okay.
and have a good
All
day.
right. All right, thank you.
Your Honor, may I ask, do you have the notes that they asked me to provide for my file
I don't
in this
have
case?
anything, ma'am.
Pardon?
No, I do not.
They sent the notes, they told me if they were in my file and that you would be receiving them when I filed this to come into court for this. At the time it was done at the window, I assumed that you had these notes. The girls at the window said that they were put in my file and that you received them. That's why what I was speaking of, I assumed you had knowledge of from the notes that were sent.
I don't have a clue what you're talking about. I have your letters. That's all I have.
May I possibly proceed to?
Ma'am,
the notes
the
that
lawyer
were
is
sent?
off. This case is closed. There is nothing else we're going to do with this today. I ruled on the motion. That's it.
May I ask how I can find out? Because you are the one who would take our direction from you or the judge. May I have your permission to go to the court window to ask them, tell them that you said you do not have the notes?
I have some letters from you in here. I don't, if that's what you're talking about, notes, I don't know.
It was pertaining to this motion, Your Honor, when they did the motion and sent it.
Ma'am, we're gonna release this money back to you. You put some money up, then it's going back to you.
May I ask you a question, Your Honor? Based on this case?
Ma'am, no, I have other cases here. You're going to have to find a lawyer if you want to ask some questions. So that's all I can tell you.
Well, I wanted to hear what you had to say.
Ma'am, I don't have anything else to say. I've ruled on the issue that's before me, and that's all I can do.
but they didn't accept rent from me. This was
Ma'am,
not
I
lawful what
call a
they did.
lawyer and talk to them about what your legal remedies are. I am not a lawyer. I am only here to rule on issues that are brought before me, which I did. That's all I can do. You have to call a lawyer to get yourself some help.
May I possibly ask Your Honor for this to go to trial?
Okay, that's it. No, you need to go down to the counter if you wish, because I have other
Thank you.
things.
May I ask for this to go to trial?
Ma'am, there is no
Information
trial.
to you.
There is, if the judgment's entered, you no longer live in the apartment. This was just a non-payment of rent case. You don't live there. There's no triable issue anymore. That's all I can tell you.
Thank you, Your Honor.
And there it is. The court's ruling is final. Denise Kirk's motion to set aside the default judgment was denied. The judge ruled there was no good cause for missing court and no meritorious defense because she no longer lived in the apartment. CK Investments retains possession, and any remaining rent claims are moot. This case highlights a key lesson. In landlord-tenant disputes, timely communication, accurate address records, and court attendance are critical. Miss a step and the law doesn't bend. If you found this case as dramatic and eye-opening as we did, hit that like button, share your thoughts in the comments, and subscribe to catch more intense, real-life courtroom battles broken down in detail.